So, hi everyone. My name is Sylvia Kamau, and we are waiting for 2 more minutes so that we can start the session. So, let's allow people to keep on streaming in, and then we start off at 5:42. We'll start. Thank you. So, hi everyone again. My name is Sylvia Kamau, as I have previously said, and I want to welcome you all for this webinar. We're going to talk about parental responsibilities, child custody and maintenance, and rights of access to children. So we're going to have an interactive session with our speaker and our moderator. For all questions that we'll have, we will ask, and the moderator will be able to ask to the speaker. So I welcome you all and I ask you to enjoy. We're going to start with a word of prayer from Sister Florence. Kindly, Sister Florence, you're welcome to lead us with a word of prayer.
Okay, I want to start by acknowledging we are in the presence of the Lord and also wishing all the women in the house a happy International Women's Day, wherever you are tuning in from. feel appreciated as a woman, feel welcome into this session. And now we begin by blessing ourselves in the name of the Father, the Son, and the Holy Spirit. Amen. We come before you, Lord, with a heart full of gratitude for the precious gift of our children. You have entrusted with us this sacred responsibility and humbly ask for your wisdom, strength, and guidance. Help us to lead with love, to nurture with patience, and to correct with kindness. Let our words be filled with encouragement, actions be examples of righteousness, and our heart be steadfast in faith. Grant us discernment to make wise decisions that will shape our children's character and future according to your will. Lord, in moments of exhaustion, renew our strength. In times of doubt, remind us of your promises. When challenges arise, let us trust in your grace. Teach us to instill in our children the values of love, honesty, humility, and righteousness. May our homes be a place of peace where children feel safe, loved, nurtured in your truth. Help us to guide them in the way they should go, that they may grow in wisdom, stature, and favor with you and with others. Thank you, Lord, for this divine calling. We surrender our children into your hands, trusting that you will complete the good work you have begun in them. And it is in Jesus' name we pray and trust. Amen.
Amen.
Thank you so much, Sister Florence, for leading us so well. And actually, according to the theme of the day, which is our parental responsibilities to the children, I would want to welcome the moderator of the day. The moderator of the day is Bernadette Nashello, who is a counselor psychologist. She's also a mediator and she's also a trainer. So she will be taking us through the days or the webinars program. So welcome, Bernadette Nashello. So you can take the lead to welcome the speaker and we start off with our day. Thank you so much and everyone enjoy the webinar.
Thank you. Thank you so much, Sylvia, for that introduction. And thank you, Sister Florence, for even committing our children. And today, even with the theme, parental responsibility and child custody, maintenance rights of access to children is our topic. And happy Women's Day, International Women's Day to all the women that we have in this forum. Feel very welcome. And as it were, I'll just take it up from where Sylvia has just said. And some of the things that today we are going to do, we are going to have an interactive session where we will look at some of those things. I know we have had previous sessions where we have looked at divorce and what it takes and what happens when people go through divorce. And now we have come to a place where now we are looking at the parental, responsibility and custody of children. Children are at the heart of our communities and our families. And therefore, even in times of when we have disputes, it's very good for us and it's very, key for us to be able to know how to handle our children and even children within the setup of the family. So, even as we proceed, we just want to, highlight And even before I go on to introduce our speaker, I just want us to have just a small bite of what we are going to be discussing this evening. So even as we go on, we are just supposed to expect a few things, that we are going to get some legal expertise from our Dr. Kimani Githongo, and also the psychological perspective, which is very important, even as we speak about our children. So the moderator, the speaker, the main speaker, who is also a lawyer and also, an expert in family law, and he's also a mediator, he's also a trainer, and he wears all these things, and also he is also an advocate, and his name is Dr. Kimani Githongo, and he is going to, take us through the legal aspect about child custody, and he has a lot of insight. And so in this webinar, we are also going to engage, because it's just not one-sided. We are going to engage with your questions and also your comments in the chat box. Please feel free, even as we proceed, to be able to communicate with us and also to be able to interact with us. And so just a small introduction of our topic, and especially looking at the psychological aspect of it. It's just not a legal separation that we are talking about when we talk about children. We're also talking about psychological restructuring. How are we going to be restructuring our children, especially when we have separation and divorce in the family unit? We also look at some of the aspects, things like, family connections, the patterns that are changing within the family for the child, then the relocation, probably different residents. Some of them will move to different cities and also even move out of the country. And so we are going to look deeply into some of these things and how they affect the children. And then we are also going to be looking at visitation rights and the communication that goes on between parents who are separated or are divorced, and the resources that we can be able to harness so that we can be able to support the children. And so feel very welcome. And I also, at this particular point, I also want to welcome Dr. Kimani. And Dr. Kimani, welcome, even as I go on and just ask a few questions, like about the legal responsibility and parenting rights. And one of those questions that I'm going to ask and throw at you, even as I welcome you as our panelist today, and you just shed a bit of light into what goes on when we are talking about parental responsibilities, and what are the legal responsibilities of each parent, when we come to divorce and separation, and how are parents' rights determined in the law, and what happens if a parent fails to meet these obligations. So feel very welcome, Dr. Kimani Githongo, even as you engage us and, educate us into how these things are handled legally. Welcome. The floor is yours.
Thank you, Bernadette. I also take this opportunity to thank Sister Florence and Sylvia for their words as we began this particular webinar today. And thank you for the short introduction you have done for the topic of today and for myself. And I'm grateful for the participants, and I wish to welcome all of them. And as we have been told, it is the International Women's Day. So happy International Women's Day to all the men and women who are here, because we are all here, descendants of Adam, as a result of a man and a woman. But I understand it is your day. Before we started this webinar, we were told during the Valentine's Day that the men went for the men's conference, and we left the ladies, and we told the ladies to wait for their day. Unfortunately, it is here with us. We cannot escape from that responsibility, even as we look at what is before us this evening. We kickstarted off this series of webinars looking at the family issues, trying to understand them, trying to see how we can be able to navigate them. We are looking at some of the common issues that families do face, whether it's the legal issues, the psychological issues, the social issues, financial issues, and any other that may come across. So we are not limited into any one particular aspect. And as we began, we said, these are conversations that we would want to have with literally everybody else. So allow me to pay tribute to all my colleagues, psychologists and therapists who are here in this particular webinar that I can recognize. And therefore, at one time or the other, questions may also be directed in your way. I'm also grateful that I can see some of my colleagues that we facilitate some of these webinars, some of these seminars, some of these shows are out there. And I'm grateful for you coming in so that we can be able to walk this journey together. And where you think that I may fall short of or I may not make it absolutely clear, you will be able to come in. But what we have been doing, and we have lined up a series of these webinars. We started off with marriage, looking at the types of marriages. Last week, we looked at separation and divorce. We are going to look at wills and other things that will be next week. And later on, we'll look at the area to do with the care for our elderly. And some of us are knocking on that particular door, will be called elderly very, very soon, as well as talking about the special population, the LGBTQ, and today in our midst, we got some of our people in that particular special population, and thank you very much for joining in. You must have seen the flyers, and we'll be welcoming you to share with us some of the issues that we may want to know as family members, as psychologists, as lawyers, as practitioners in other different fields. And it is very, very encouraging. We'll later on be joined by some other people who are experts in the sign language interpretation, and they'll be doing sign interpretation for those who are viewing us on YouTube, as well as on this particular Zoom platform. So going back to our topic for today, parental responsibilities. And it is very important that we look to demystify some of these issues that come along. But before we go to the parental responsibilities, we are guided by the Children's Act. And the Children's Act of 2022. There was the Children's Act of 2001, but then it was replaced by now the Children's Act of 2022. It gave more application onto the issues that we face on a day-to-day basis, and most of the issues have been clearly spelled out there. So I am sharing my screen here so that we can work together and see what are the rights that children do have. What are we supposed to talk about the rights of the children? Okay, I don't know why the screen is not showing on your end. Is it showing on your end?
Yes, it is.
Yes, it is.
Okay. It is my other computer which is not showing. So that is the Children's Act of 2022 and a revised edition of the 2001 Act. It came into operation on the 26th of July 2022. And some of the rights for the child are there given as a realization of the rights of the child, survival and development of the child. That is what we should be able to give the child. The best interests. A child is entitled to a name and nationality. That is under Section 7. A child is entitled not to be discriminated. And then when we have some special needs of children, then there could be a differential treatment, but differential treatment is not discrimination. Then there is the right to parental care, and that is where now we kick in as a parent. a right to social support and social security, right to basic education, and that is why you see people being taken to court if they're not taking their children to court. There is a right to leisure and recreation, play and entertainment under Section 14. A child has got also the right to religious education. A child has got the right to healthcare, the right to inheritance. A child has got the right of protection from child labor and protection from armed conflict. And when we have children with disabilities or special needs, then they have their rights. And then at Section 21, we got the rights of intersex children, those who are born with both reproductive organs. They're given their rights as well. The children have got the rights from abuse. Children have got the right to protection from harmful cultural practices, protection from drugs and substance abuse, right to freedom from torture, detention of children in conflict within the law. Those are rights. Right to privacy, and right to assemble, demonstrate, petition, and participate in public life. You may wonder, can children actually assemble and demonstrate? And the answer is yes. We actually saw this. Was it in 2013 or 2014 when there were children around Langata Road? There's a primary school called Langata Road Primary School, and there was an attempt to grab their compound, and they went on the road and they were demonstrating. Yes, they got the right to assemble, demonstrate, and even to petition for their rights. And then Section 29 talks about how do you enforce the rights of this particular child. Then coming to what Madam Bernadette, you have asked me about the parental responsibilities. The parental responsibilities are given under Section 30, Section 31, and Section 32. And all those give now the right of the parents and the responsibilities, the legal responsibilities of children. But these legal responsibilities as well encompass the psychological aspects of it. And these ones are also given under the law. Let me go to Schedule 1 of the Act. That is the one that gives all those responsibilities of the children. It is called Schedule number 1. And there are very, very many responsibilities for the children. These are given under Section 8 of the Act. And those are the best interests of the child. Let me see whether I can try to increase the font. Yeah, so the best interest of the child, we are talking about the issues to do with the age, maturity, stage of development, gender background, and any other relevant characteristic of the child. Those are the best interest considerations that parents and everybody else should have for the child. And we are talking about now the parental responsibilities. If there is any distinct special needs arising from chronic ailment or disability, we take care of them. The relationship of the child with the children's parents or guardians or any other persons who may significantly affect the children's welfare. And that is critical so that we do not deny our children the right to mingle with their cousins, with their aunts, with their friends, and everybody else. The preference of the child is old enough to express a meaningful preference. And this comes in because a child is taken to be one under the age of 18. For instance, children have got preferences for career choices. Children have got preferences for clothing, preferences even for school, or even the religion they may want to attend to. And if they are old enough to express a meaningful preference, then you should take it into consideration. And that is your responsibility as a guardian or a parent. And then there is the duration and adequacy of the children's current living arrangements and the desirability of maintaining continuity the stability of any proposed living arrangements for that particular child. And I can go on go all the way to number 18, if I'm not wrong. Was it number 18? Yes, number 18. And therefore, you can have a look at all those. They incorporate the legal responsibilities of the parents, and they also incorporate the psychological, among other considerations. As you can see there, their financial, their religion, their educational, among very many other aspects. But let us zero in on one aspect. Who has got parental responsibility? The parental responsibility is given under section 30A2. And in a nutshell is that parents have got equal responsibility. And what does that mean? This was an improvement from the original Children's Act. So this Children's Act of 2022 gave an improvement on the parental responsibility, that each one of us, father, mother, whether married or not married, to each other, you got equal responsibility. And equal responsibility simply means 50-50. And therefore, if it is school fees, you contribute 50-50. If it is entertainment, you contribute 50-50. This was to remove the challenges that were there before. When me as a man, if I'm not gainfully employed, or if the mother of the child, whether we are married or not married, has got better income than I have, I can go to court and say the mother will be contributing more than me, or the other way around. The mother of the child says I'll be contributing more to the upkeep, maintenance of the child. But now the law is clear, is that it is 50-50. So if for whatever reason I'm not living with a mother, and the mother chooses a school, which is about 50,000 per term in school fees, then I cannot be called upon to pay the whole 50,000 or 30,000. It will be split into two. And that means she bears 50%, I bear 50%. So even if you go to court today, even if you go to mediation today, even if you go to any other kind of arrangement, that is the legal position. However, that does not mean that parents cannot have their own arrangement, especially when there is a lot of harmony and the family is not dysfunction. Even if I'm not staying with the mother of my child and we are actually agreeing with one another, that should not be any issue whatsoever. We should be contributing for the maintenance of that particular child at 50-50 basis. So that is the legal responsibility for the parents in accordance with the law. And I do believe psychologically that settles in so many of the issues that we have been having prior to 2022. Back to you, Madam Bernadette.
Thank you so much, Daktari, and for that insight. And all those clauses in the Children's Act of 2022 are providing us with so much insight on how to handle parental responsibilities. However, Daktari, maybe you should just shed a bit more light on what happens if a parent fails to meet their obligations according to just that schedule and what is expected of them. What if a parent fails, and are there circumstances that a parent could be able to not meet the needs of the children? What happens in such a case?
Allow us to start at the bottom line, that maybe it is not the wish of such a parent not to meet the obligations. Mm-hmm. And the positive side is that maybe they're having some challenges here and there. Mm-hmm. And as we have been saying in this family webinar series, we have been saying that let us be very, very sober. Let us observe emotional intelligence when you're dealing with family matters. And children are very, very sensitive. And children observe, children see what we are actually doing. And therefore, going back to what I said earlier, it will only require both parents to be a little bit sensible and reasonable and talk about the arrangements that are going to be made for these particular children. If you have to make arrangements that you may have to move from where you are staying and go to a lower ranking estate or somewhere else so that you can save on the rent, among very many other things, or also cutting on the expenditure at the house, is absolutely welcome. If for whatever reason one parent is not able to contribute the maintenance, and the other one can be able to do that, it is okay. We can get that kind of an arrangement. However, there are those who pretend they cannot be able to maintain, yet they are capable of doing that. Instead of punishing the child, what the capable parent can be able to do is to continue with the maintenance, paying all the bills, the school fees, among other things, and keep a record. And then at a one time, you can actually demand to be paid for what you have contributed for the maintenance of this particular child. Whether you go to court, whether you engage the services of a lawyer to demand, and if the demand is not met, then it could end up being a court case where I show what I have been contributing. And if I win that particular case, then we can execute it. That is the language of the court, or basically try to recover it through other means. Is it that we are going to sell your car if you have a car? Is it you're going to sell your household goods? Is it that you are going to attach your salary or whatever it is? And in particular, for those parents who may not actually be living together with this particular child. So there is no running away. We have seen cases in court, people come and say, no, I'm not employed. No, I cannot be able to do whatever. But the liability or the amount you kept will be kept on, and it will keep on piling up until such a time that you'll be called upon to actually pay for it. So let us observe some little bit of sobriety and reasonableness. We do not take care of our children so that we get paid later on. We are taking care of our children. But in the event that one person is hot-headed or unreasonable, then we may have to resort to the courts. But the best thing is that if we are in agreement, we don't have to go into those particular rough measures to enforce you taking care of your own child. Back to you, Bernadette.
Thank you so much, Daktari. And I like that the child's, even psychological well-being and everything is taken care of under this act, and even just to understand that, children actually, thrive on stability as opposed to where there is chaos. So it's good for us, even as parents, just having, to understand that the child is independent, and the fact that they might not, actually they did not contribute to the separation of the parents or the divorce that is taking place. So it's always good to take care of that. And even looking at the financial stability, children also ought not to be used against each other. Like I am not providing because my wife is not with me, or my husband, did whatever they did, or is, being a bit stubborn. So we shouldn't use those, those grounds in order to, to make the child suffer. And so the economic hardships also affect psychologically the child in a very negative way. And also involvement of the parent is a key thing, and a psychological, need that needs to be met. So thank you so much for that. And so taking care of the best interest of the child is something that is good. So going even forward, when we're looking at the best interest of the child and who have special needs and special cases, and I think you have already touched on that, Daktari. And some of those questions that probably might come up are, how is the best interest of the child defined legally? How do we define this legally? And then how are special needs and exceptions and expenses, handled when we come about it legally? How do we, determine, beyond just, like looking at the law, how do we navigate that? Because special needs, and sometimes, we look at special needs in terms of the children, but sometimes even one parent can be incapacitated. not that they wanted, but somehow they have a challenge and they are abled differently. So are the laws just apply equally, or now are there special occasion, a special consideration when we come to special needs of children and special needs of parents? Back to you, Dr.
Thank you. Thank you. Section 8 of the Act, the Children's Act, talks about the best interests of the children. And Schedule 1 gives the 18 components of the best interest of the children. But without even going back to the Act or itself, there is not a single child who comes to this particular world expecting that they're not going to be treated well in every particular aspect that you may think of. We sometimes summarize them in terms of shelter, education, and the other maintenance like food and clothing, among very many other elements that we know. But they also have a right to have a peaceful environment. The peaceful environment that is granted by both parents. And these both parents, they may be living together or they are not living together. Or I may have gotten a child out of wedlock, and therefore I'm not going to stay with the lady together, and that particular child will stay permanently with the lady. But she or he is entitled to 100% to a peaceful enjoyment of their lives. And if for whatever reason that the parents themselves, and when I talk about the parents, remember, I'm talking about the father and the mother who brought that particular child into this world. Again, I repeat, whether living together or not living together. The parents of the child bear that particular responsibility, I said, on an equal basis, and we cannot overlook those parental responsibilities. So all of them are there, and either the courts or the children welfare officers, or as is happening currently, you can go to a counselor or therapist or a mediator who can be able to sit you down and you actually engage in an agreement, and that is provided for under Section 33 of the Act, which says that me and the mother of the child, we can enter into a parental agreement. That parental agreement is going to talk about all the needs of the child and who is going to take care of this and the other. And that now, if we are sober enough, reasonable enough, we will be able to say, since I'm earning more and the other person is not in a position to contribute as much as I can, then this is what I'll be doing. Who will stay with the custody, who will be having the custody of the children, this particular person or the other one. So we all are in agreement about what will happen. That now we are not shackled. We are not tied by the 50-50% in the event that one particular parent is not capable of providing. This always happens when there is a peaceful resolution, peaceful agreement between the parties, and the family is functional to a great extent. And therefore, parental responsibility agreement, they are now recognized by the courts. You don't need to go to the courts. You only need to sit down with somebody else and you draft that parental responsibility agreement. If you are drafting it before a mediator, the mediator will sign it. If we are not drafting it before a mediator, maybe a counselor psychologist to be there. But there is no also requirement that it be drafted before any other person. You too can sit down and draft it, and each party maintains a copy. For the parents who are living together, that may not be the position. It is more applicable to the parents who are not living together with the child, and in particular those who are not married to each other, or maybe you are married and we divorced or we separated, and that agreement can only be set aside by the court. So basically, the moment you append your signature for that parental responsibility agreement, then you tie yourself, and if you want to get out of it, then it is only the court which can actually dissolve that particular parental agreement. That gives some little bit of stability for the child in terms of the financial, the custody, the psychological, as well as the legal aspect of the best interests of the child. Back to you, Bernadette.
Thank you so much. And even as we are talking about these special circumstances where now we have these special needs children and all that, and that all these things have been taken care of, and just off, I'm just thinking, what if, for example, a couple was married and they had one of the parents came with a child, and the child was not born in that marriage, but however is considered to be a child in that family by the virtue that they have grown up there, and they know these two parents as the mother and the father. They really don't know their biological other parent, but one of their parents is a biological parent. I'm just wondering, are these laws also applicable to them, or are they excluded from this arrangement?
Thank you for that. And that question keeps on coming up a lot. Initially, the Children Act of 2001 had a clause on it, but regrettably, the Children's Act of 2022 has removed it, but it has not left any gap whatsoever. What the law used to be for the 2001 was that if I stayed with a child who came to my household because the lady had another child out there, or I came with a child and the lady who I'm married to is not the mother of that particular child, if you stayed with it for 2 years, then you acquire parental responsibility. But now that has been removed. What is happening is that you go to another section of that law, which is called adoption. Me, as a father of the child, together with the wife I have married, we adopt that particular child, and therefore she or he gets all the legal rights like a biological child. Okay. So that is the current position. If the mother came with a child, married to me, then we go to court and we file for an adoption, and we get an adoption certificate, and that particular child becomes ours by adoption, and she or he has got all the rights like a biological child. Okay. Back to you, Bernadette.
Thank you for even shedding that light that a child ought to be. So in other words, parents, it's like parents need to be keen on these things. When you have another child, the adoption has to be there for them to be considered legally, by adoption, that they belong to this family. So even looking at even their psychological needs, it's just that beyond the legal definition, where we are saying courts define the best interest in terms of custody and financial support and access, psychologists define it as emotional security, stability, and quality of parental responsibility. So I think as parents, we need to be conscious of that there has to be emotional security and stability and quality of parental responsibility and relationships between these two parents, even if there is separation or if there is separation or divorce. So low parental conflicts also produce high conflicts, leads to emotional trauma. And so maybe we need to be also very careful, even as we examine the life of a child after divorce or separation. And strong parent-child bond also needs to be secured in relationships with both parents. And, also establishing probably also predictable routines for these children so that there is consistency and so that we can reduce anxiety. And also special needs and divorce, we need to be more we need to realize that these children have become vulnerable, and so disrupting the caregiving also affects them psychologically. So we need to, coordinate medical and educational and emotional support for them so that we can harness, the well-being of these children. And so, Daktari, I'll still come back to you, obviously, also about parental, relocation and decision making, where we are looking at what happens if one parent decides to relocate. And I can see in our chat box, we have a lot of questions, and thank you so much for those questions. We shall come back to the questions at the tail end of our discussion. And even as we discuss all these things, I'm sure some of those questions are getting, answered. But just to answer some of those questions, we're asking, Daktari, what happens if one parent decides to relocate? And then what decisions require mutual agreements in the relocation? And then how is the information about a child shared amongst these parents now that probably one of the parents is relocating, maybe to another town, maybe to another country? What are some of the legal implications and considerations should we make when we come to children and separation and also relocation?
Allow me to start by saying that the family is taken like a stable unit, and you have said it very, very well. We are looking at a stable unit, at a very, very functional family. However, dysfunctionals come in, and parents may not agree at 100%. And what we have been saying is that every single decision taken in the best interest of the child should be an agreed decision by literally everybody else. Obviously, there are some little things that families leave to maybe one parent and to the other. For instance, if it is something like the meals, we know from the African culture that we are in, the mothers are the best nutritionists and pediatricians that we have, and they are able to take care of those particular elements. We don't have to keep in every single day saying, let us agree on the meal, let us agree on something else. So when the families are very, very functional, these things do not come in. And even therefore, the issue of relocation will not come in because already we are in agreement. But however, we know families have got their own issues. And when it comes to an issue like relocation, and it's not only relocation, even changing of a school of a child, we must, first of all, even before we engage in that particular debate with the other parent, we look at backwards the best interest of the child. Sometimes I know we just make decisions. We are moving from this estate, we're moving from this village, we're moving from this location to another location. We never take the interest of the children at heart. These children are losing their playmates. These children are losing their best friends within the estate, within the school, and everything else, including the environment that they're used to. They're used to this particular route. Now they are no longer going to be that particular route. Are they comfortable or not? We wake up one day and we're shifting, and we're not even telling them about anything. That is not psychologically settling. That is not healthy emotionally for the children. And therefore, we should be able to prepare them that we are now relocating. You're going to change school. You're going to have other friends other than these ones that you're going to have. The best thing is that children make friends very, very easily, unlike the adults, but still, we owe a duty to them to actually prepare them for that particular aspect. Now, if it comes to relocation from one area to the other, and the parents have made this decision on account of very many factors, including promoting where they were staying, advancing to another area. You may think it is in the best interest of the child. It may not be. But when that decision is being made, let the children also be involved in it. However, we have seen lots of issues in courts where people are saying, why should I tell the father and he does not take care of this particular child? Or why should I tell the mother and she will just become a nuisance, among very many other bad and negative elements. What we normally do, and the court should normally do, is look at the best interest of the child. I was in court actually just last week when a parent was talking about shifting school of a child in the middle of the term, and the court said, no, that is not very, very comfortable. We need to think about the child's welfare. And therefore, even in location, there the people talk, but if they cannot be able to talk, as I said, we got people called our best friends, our relatives. We got pastors, we got therapists, we got counselors, we got mediators. And at the tail end of it is the legal process going to court. But that should not be the best option. But if the worst came to the worst and we cannot be able to agree, and you want to take my child out of the country or out of the county, and there's those arrangements of how do I see the child, how do I take care of this particular child, then if in the absence of any agreement, then regrettably, we may have to go to the court. And the court will always look at the best interest of the child, not about you, the parent. We look at the best interest of the child. But we also look at who is in a position to give the best interest of that child. If my wife is relocating to Canada, to America, is it in the best interest of the child? And will she be in a position to give the best interest of the child? Or is it me who is remaining here or remaining in Nairobi as she relocates to Mombasa or any other sort of relocation? So all those aspects will be looked into. And how does the court look at it? We look at the living arrangements. You look at the income of the person. We look at where you are going, the schools you are going to enroll this particular child, among very many other things, which are given under the Schedule 1. And if possible, children welfare officers are involved who actually give a report about my living conditions, the environment we are in at, maybe my income, my employment, also the mother, where she is going. We look at all those circumstances, and then the court can give a decision. Normally, obviously, court decisions will go in favor of one and against the other. And we are discouraging a lot going to courts. And that is why we are talking about understanding these family issues. Because when we keep on fighting, one will lose, the other one will actually be able to suffer, to win, and the other one to lose. And therefore, if we can be able to be sober enough and involve other people who are reasonable, who can be able to help us navigate that particular challenge, the better. But in terms of relocation, let us agree, all of us, and look at the best interest of the child. Back to you, Bernadette.
Thank you. Thank you so much, Daktari. From what I've just heard you say is that, shared decision-making actually, it can reduce a lot of anxiety within the family structure, including to the children. Because basically, if we are not able to agree on some of these decisions and look at the best interest of the child, then we actually are causing harm. And so we stand, in a position where we risk going back and forth to court, just to make some very, key decisions, whereby if we make shared decision, we can actually come up with the best interest of the child. And that is so good. So even in long distance relationships, actually psychologically, we can even say, sometimes they create a lot of emotional gaps for the children. So we are to consider, a lot about the child being disrupted from the attachments that they know, because in a setup of a family, the children just don't belong to the mother and the father. There is also the extended family. There are the schools that they attend to, their, attachment to their peers, attachment to other families, their aunts, their uncles. So I think shared decision-making would save us a whole lot, of trouble if we are able to sit down and examine deeply about the child and what we are doing to the child, as opposed to, I am not getting along with my spouse, and so I want to be as far as possible from them So I might want to live in another country. I might want to look at being as far as possible from them. So we might want to really engage and also to look at the best interest of the child. So thank you so much because of that. And so now we are getting even more enlightened. Yeah? And so now could we kindly examine remarriage, death, of a partner and step families, because sometimes when families break up, they also go and join into another family. Like, for example, a husband or a wife will go on to marrying another partner or getting married somewhere else where there are other children. So what really happens if either parents remarries, for example? And then, and how do we engage with stepchildren and and other step families like stepfathers, stepmothers? Is there a provision in the Children's Act that embraces this and sees that the rights of both children and is taken care of? And then what happens in case we lose also a parent? Because sometimes we do, and it happens that a child can actually lose a parent while they have suffered this this divorce or separation. So maybe kindly shed a bit of light into these areas.
Thank you, Bernadette. And even as I go along, because as I said, there are very many people here who will facilitate this type of workshops and seminars. I will also be giving an opportunity to some of them to have an input on some of these issues, because there are some issues we come across over and over again. So as I talk about the legal perspective, I would want to call upon, I hope there's not an ambush, Josephine Masharia. I know we work together very well. We have worked over the years. Let alone, I will call upon her to talk about how do we deal with the step of families, the stepmother, the step brothers, cousins, among very many other things. But allow me to say this, that the law will not prescribe how you handle your family. The law prescribes the best interest of the child. If you are remarrying, if there is an issue of a divorce and separation, and then you have each of the parties will have to remarry, or in the unfortunate event that one of the spouse dies, and we will also have to remarry, or we are not married to one another, but we have children. I have my children, and there are other children I have out there with another lady out there. How do we actually ensure that there is a lot of stability psychologically, socially, and everything else for the children? And basically, the clarion call here should be integration, proper integration of both families, all the children that I have, together with those ones who are not living with me or not living with me. And I don't treat one set of children better than I treat the other set of children who are out there. And that also calls upon the blended families, okay. And that is what the law would look at. What are the best interests of these children? We are not looking at, is it blended, is it not blended? We are looking at, these are the children from somebody called Kimani. He is in a blended family, or he has got other children out there, even if not married to that other mother of the children. How do we look at the best interest of these particular children? Are we going to have a lot of fights? Are we going to have a lot of bitterness between the children, between the mothers, between the extended families, and all those kind of things? And it behoves upon the parents. And I will not tire of talking about these words called reasonableness, emotional intelligence, and sobriety between the parents. The children never sought your permission. to come to this world, if I may use that bad language. They just found themselves in this particular situation. It is for you to give the best interest of all of them. Some don't go to this school, and the others go to a lower cadre school or a higher cadre of a school. We should be able to integrate this. And remember, these children are seeing it. We are not the people who should psychologically affect them when they get to know one another. And I know sometimes we say they shouldn't know one another. Regrettably, it is that most of the times, even as we try to deny that they don't know one another, or they don't know about the life the father is leading, or the life the mother is leading, unfortunately, they actually do know. All right? And you come out as a very bad parent to them because you are pretending, or you're trying to not to tell the truth about. At a later stage, when they get into the adolescent and the curiosity comes in and they want to know so many things, actually the parents become even more depressed when questions start coming around. And when you hear those questions being asked, it is because the children are suspicious of you, that you're not telling the truth. And to avoid that situation, can you balance it off well? Can you be able to be reasonable enough not to withhold any information from the child? But before I wind up, if Josephine Macharia is able to unmute and talk about this topic, because we have handled it with you before, maybe you can talk about how the step families, they should relate with one another. Josephine, are you in a position to?
Yes, Kimani, I am here, and thank you for that question. I think you've covered it so well because you've said exactly what is literally the minimum. The responsibility falls upon the parents. It's because children really, they had no part to play in being there, whether they are from this family or the other family. It is really about parents. And it is the parents' responsibility to make sure that there is equitable, that the children are dealt with equally, right? Now, the experience usually is that that is not the case. But I agree with you, Kimani. I'd repeat, parents, it is your responsibility to now make sure that these things are dealt with well. When I come in with my children, as I marry a man who is not, if I have children outside of my marriage, it behoves on me to make sure that my children are protected first. If you come with children that you want me to care for, it behoves on you to have really communicated with me to be able to take care of those children. It is an agreement. And these are some things that we begin to want people to actually talk about before they actually get together, that you have an agreement of how we are going to treat the children. Because children, like Kimani says, it's not what you say that they hear, it's what you do, right? And they can tell when you're not behaving the same with us and behaving the same with the others. They can tell when you're hiding something. Children have a natural vibe to their parents. They can tell when you're lying and when you're not telling the truth. So eventually they will always know there is something wrong here, and they will always investigate it. And the way life seems to be is that they always get some information from somewhere that eventually they will confront you with. So truthfulness, deliberate effort on the parents to do what is right, and to give the truth. Children love the truth from their parents, even when it's untidy. They want to hear it from the parents. So that is I think that's what I would only add, but it's only to add to what you already said, Kimani. Thank you.
Thank you. Thank you very much, Josephine. We ran some seminars, parental seminars with Madam Josephine. We have done that for about 10 years now. Madam Josephine is a counseling psychologist at master's level and also does a lot of therapy and also a professional mediator. Thank you very much for coming to my aid, Josephine. Thank you. Back to you, Bernadette.
Thank you so much, Madam Josephine Masharia. We really appreciate all that insight into, especially, parenting, and also when we have other siblings, stepmothers, stepbrothers, and step cousins, and blended families. However, Daktari, I'm just wondering, I know you have tackled, the remarriage, but now, what happens in death, especially if the child loses one parent? Could there be other things that can be done? Because we have seen in our society mostly that if there was a divorce and maybe a separation, should one parent die, the rights of the children who have been left behind. Suppose maybe they were left with the mother or the father, and the father passed on or the mother passed on. Those children tend to be very neglected. So is there a provision that actually, the continuous care that they used to get, or the compensation of the gap that has been left by the parent who has left through a way of death? Is there a way that these children can still be taken care of and not neglected?
Thank you very much, Abandon, for that. And this is a social question, basically, because legally we are still looking at the best interest of the children.
Yes.
But when death knocks and it has got no notice whatsoever, and even if somebody has been ailing for long, the children go through a lot of trauma, grief, and the loss. And psychologically, we need to take them through the grief therapy so that they get to cope with the situation. But in the event there is another parent who has been left, the responsibility falls on that particular parent to actually take up the rights of those particular children, in the same way that they would have been taken care of in the presence of the other spouse or parent who has passed on. In the event that this parent is going to remarry, then we ensure that the rights, the responsibilities, and what is supposed to be done for the children is not in any way interfered with. And therefore, in the issue of neglect, the children have got the right on their own to go to court and demand that their rights be actually enforced. And this can be enforced through another guardian, through another caregiver, or through the council. There's a council which has been constituted under the law of the children, and the children can approach that particular council and they can be taken care of. And so even in the breaded families, when one maybe parent dies, it is not the right of any one of the other parents who are left behind to neglect the needs of the children. The needs of the children have to be taken care of, even in the absence of one particular parent. And that also goes to the issue of inheritance. And inheritance is one of the rights of children, that they have the right to actually inherit. And therefore, you cannot be able to disinherit them. If you come in and you are a new parent and you're saying these ones are not going to inherit or something like that, no, the right to inheritance is a given right to the children. So issues of neglect basically are legal issues that can be addressed by the court. Back to you.
Thank you so much, even for clarifying that. I know it has been in our communities and societies, it has been quite a mystery for, especially when children are left behind. It has never been so clear that, that children have a leeway to be able to be taken care of, and especially if there is a legal guardian over them, and when they are young, they can actually be able to go to the courts and have these children actually have access to the right, their own rights, a right to education, right to, proper health, and even to inherit, because we have seen so many, children, when they are left by their parents, they are disinherited, especially by by other relatives who come and just take everything that belongs to them. So, and this actually really tells us so much and encourages us, even for us to have such webinars, that we get so enlightened and to get to understand the rights of the children, even in the absence of their own parents. So thank you so much for that insight, also for Madam Josephine, to be able to help us understand. And so even from psychological perspective, we see that it is really good that we do not betray our children, and even when we have step parents, we still continue to take care of these children, and that we have even leeways that we can actually access help for these particular children, and also to allow them, when they are going through grief and losses, we allow them to and support them even psychologically by taking them up for child therapy. And if there are resources that can be allocated to the children, it's good to know that actually parents and even those ones who are guardians, in the absence of a parent, they can take up these services, and there are resources that can be allocated to them so that they can find the necessary help to be able to cope with the loss and grief. And at this point in time, we will go now back to the questions. I know our audience have now, been able to give us a lot of questions so that we can be able to identify to be able to answer their questions. So we have Jane Gaduma, who asked us, "Good evening. Kindly advise where a mediator could do training of trainers on mediation, and also any institute offering postgraduate diploma in ADR or conflict resolution." And because we have also other panelists, Sister Florence, you can be able to answer this question, if you don't mind, about where they can have this training on mediation.
Thank you so much, Bernadette. Mediation training for TOT, as the person is asking. Okay, one of the places where they are training is the judiciary, and it is taking the already accredited mediators. And we are also planning, as part of our training through BTI, the host for these webinars, to train TOTs. So keep watching. We will maybe soon be posting for that training. If you are a trained mediator, we will be able to inform you in due course. As far as a postgraduate diploma in ADR is concerned, and the conflict resolution, remember ADR is a very young practice or discipline. So far, I'm not very sure where a diploma for ADR will be offered, because unless it's conflict resolution, which is being offered by several universities. But as for ADR as it stands, right now we may not be having an institution just offering that per se. Thank you. Back to you, Bernadette.
Thank you so much, Sister Florence. We really appreciate that. And even these webinars also, it's good to note that also these webinars also offer us, resources where we can actually be able to train if we are interested. And so thank you so much for that insight, and even for helping those people who are looking for such kind of trainings. So now we have a few questions here. And I think I'll give this to Dr. Kimani, because they are also a bit legal, because one of the participants asks, what if the father denies the child? And then this one is also coupled with another one, that in case of separation, what determines who gets child custody? And does this also apply to a child born out of marriage? I think we have already addressed that, a child born out of marriage, and Dr. Kimani has given us a bit of insight. But at least for this one, who is being denied child, visitation rights, and also what determines who gets, custody. Kindly, Dr. Kimani, you can maybe answer those two questions.
That's a very interesting question, Bernadette, about what if the father denies the paternity or denies his another one. And this is a question that has been there from time immemorial. And in my own culture, what we used to do is wait for the child to be born. And we look at the nose, at the mouth, at the legs, and see, this one looks like him, and the matter is sorted out. The elders were very good at that, very easy. Number two, we went out of that in the 1960s, the 1970s. We came to blood test. But now, unfortunately, the child may be mine, but does not carry my blood group. It goes to the mother's blood group. So that one was not also a very reliable test. But now we have DNA. And DNA is 99.999% correct. And there is no issue. All what happens is let the lady just go to court and ask for an order that the father and the child subject themselves to DNA. And you go and court order will be given immediately. The court does not even think twice about that one. Kimani, you're denying paternity, it's okay. If it comes out positive, paternity has been confirmed. If it comes out negative, you're free. What is the fear? Just go for it. And you troop to Kenyatta National Hospital and Camry, just across Bagadi. And I think now it was about, I think it was about 7,000. And now I think it has been increased to about 21. I saw a notice increasing it to about 21,000. And that is what the person requesting the DNA will pay. If for whatever reason it comes out positive and I had denied, I pay for the DNA. If it comes negative and I had denied, the mother of the child pays for that particular DNA. So it's very, very easy. And DNA would never go wrong unless there's corruption in the medical field, that it can be swapped. It will never, ever go wrong. So ladies, never worry if a man denies paternity and you're sure, we have been told it's only the mother or the child who can know the father. So ladies, don't worry, just apply to the court. It will be a very, very easy thing to do. If the father does not voluntarily subject himself to the DNA, the court will not blink. Now, in the event of a separation or divorce for that matter, we need to talk about the custody of the child. That comes like in a twin, triple. It's a triplet. The first one is who goes with the child, that is custody. Or what about the maintenance of the child? The parent who is not going to have the custody, what rights of access does that particular parent have to be seeing the child? Because the parent has got a right to see the child at any one particular time. And I started off by saying, if there is sobriety in emotional intelligence and people are reasonable, what would happen is that we can agree. Let the child be left with me or let the child go with the mother. If we don't agree on that, we can engage the other mechanisms. We have said about counseling, our friends. If it fails, then we go to court. For the court to give custody, it must be ascertained that the parent who is going to go with this particular child is going to give the best interest of this particular child. And allow me to demystify some of the myths that have been there, that girl children should go with the mother or girl children should always be with the mother. No, that is a myth. How about if the mother is a very, very great alcoholic, cannot take care of these children? So the father will take care of the children. So the court will look at the best interest of the child. Who is it that can be able to give the best interest? Even if the child is 6 months, all right? So if the father is the one who is capable of giving the best interest of the child, the father will be given custody. And the best interest is not the house I'm staying. I could be staying in a 5-bedroom house, but I am rarely there. I am not psychologically present. Emotionally, I'm not present for the child. So that does not determine. So we look at the psychological perspective, the infrastructure that is there, the care, like who is going to watch these children or clean them up or cook for them. All those kind of things are looked at by the court. And the children welfare officers will be sent. It is not only me saying, I live here, and the other person lives elsewhere. No, the children welfare officers will visit both homes. And if these children are like the age of 10 and above, and they're expressive, they can be able to say, they can actually say, me, I want to be the mother, me, I want to be the father. And that consideration will be taken care of. So again, it is the best interest of the child. Now, so we have talked about custody, then we talk about maintenance, because even as I stay with the children, there is the issue of maintenance. Who is best placed to maintain or to give the maintenance of these children? And number 3, if I am denied the children, not clearly that negative denial, if all circumstances point that it is the mother who should be the children, then I should be given the rights of access. When is it that I'm going to be seeing these particular children? And most things that we do is that the children are seen by the other parent who is not with them every alternate week. That is after every 14 days, every second week. You pick them up on a Saturday, you stay with them overnight, and you bring them back on Sunday. We have seen instances where parents fight their wars through the children. I'm supposed to pick them at 10. I stay, I pick them at 4 or something like that. I'm supposed to return them at about 4 the next day, and they return them midnight or something like that. That should not be encouraged. Let us be sensible for all the parties. If I'm denied the rights of custody because of my circumstances, then we should talk about access, and it be handled very, very well without any sort of acrimony. And when I'm with the children, let me not poison them. Let me not turn them into investigators. What does your mother do? Who comes to visit there? What do you eat? What happens there? No, no, no. Also, when they go back to the mother, let the mother not to be an investigator. What happened? Where were you taken? All those kind of things. Let us be cordial. Let us just look at the welfare of the children and not fight our battles with through the children. Back to you, Madam.
Thank you. Thank you so much, Dr. And even just, even as you were speaking, and I was like, you're busting a myth, the cultural myth that, other people, different cultures in Kenya hold that either the children belong to the mother or the children belong to the father. That cultural aspect also, it also binds us in a way that sometimes, unfortunately, it does not work for the benefit of the child and to protect the child's right, and also to even allow access to that. So this, I know we are bound by the law and the laws of the land. So it's good for us to know, because this empowers us for us to also come out of our cultural, aspects of where we deny the child the rights to be able to see, some parents the rights to be able to understand that a child also has rights under the Constitution of Kenya. So really, thank you so much for shedding that light. So now we also have another question that what happens if a father takes the child and refuses the mother to visit the child who has taken the child to the grandmother? What I'm understanding from this question is that, like, if the father has taken the child, and now the child has been taken to the grandmother, and this is the cultural aspect, I believe, that sometimes dictates this, that the father takes the child because probably feels that this is my child, and culturally they are mine, and I take this child to my mother to take care of her or him because I am not in a position, or for whatever reason. Then you deny the mother or the father access to this child. So what happens in that case? And then if both parents are responsible for a child, but are separated, and the spouse of one of the child's parents want to adopt this child, is it possible? So, for example, a couple has separated, and then one parent goes with a child and gets married, or it's in another relationship. Can the other parent on the other side adopt this child? So those are two questions.
Allow me to say that the children belong to the parents. The children have never belonged to grandmothers. The children have never belonged to aunts or to my brothers or to my sisters, unless in very special circumstances where the where the parents are not in any capacity to take care of these particular children. And therefore, it does not come to be that I, as a father, take the child from the biological mother and take her or him to my mother, who happens to be the grandmother. No way. That would not be acceptable at all for the purposes of the best interest of the children. And therefore, if all mechanisms to resolve that dispute, that the child goes to the mother other than going to a grandmother, and then if they all fail, you go to court, and the court will actually grant an order that the child come back to the mother. But how does the child come back to the mother? Again, we look at the best interest of the children. We look at the best interest of the children. Is it that this mother who is being denied is so helpless or hopeless that cannot be able to take care of the interest of this particular child? If the mother is not in a position, then the father will be given that child. But is not given the child to take to the grandmother. No, it is to stay with this particular child, unless special circumstances that the father, even when he has been given this particular child, cannot take care of the child. So a guardian will be appointed. A guardian will be appointed. And if the grandmother fits to be appointed a guardian, so be it. That will be the way it is. But it is never that fathers take the children, ship them to the village, ship them to an aunt, ship them to another person. No way. They should stay with that particular child. If they are not capable of staying with that particular child, then they hand over the child back to the mother. We are talking about the parents, not other people. Now, this question about adoption needs some little bit of rethinking, because the child, first of all, must be available for adoption. And how do we go about that? It is not that my wife, who I have just married, comes with another child and I have the right to adopt. No, I don't have the automatic right to adopt that particular child. What happens is the child must be available for adoption. What does that mean? That means that we'll have to go to the biological parent, the father or the mother. And the father or the mother will have to sign a consent saying, I hereby release the child for adoption. Remember, if my wife came with a child and there is a biological father there, the biological father has got an equal right with my wife. All right. Me, I'm only like a foster or a guardian taking care of this child when that particular child is actually in my custody. All right. And therefore, if I want to adopt that child legally together with my wife, the mother of that particular child, then the consent must be given by the other parent, releasing the child and saying the child is available for adoption. And even when the child is the ones who are picked up after being abandoned by their parents, there is a child welfare society which gives that particular consent and says, yes, we picked up this particular child, or this child was brought over there, and therefore the child does not have a mother or something like that, and therefore the child is free for adoption. And therefore, the consent is given by the Child Welfare Society. So if I need to adopt a child that came to me, or my wife needs to adopt a child I came with, then we go through the legal process of adoption. And we get rid of the birth certificate of the child, and instead we get an adoption certificate that legally binds us to the child. Back to you.
Thank you. Thank you so much for all that insight. It's amazing because sometimes, we see things happening in our societies and we are not really aware of the legal rights of the child and what can be done in some of these dilemmas. So thank you so much for sorting out, that dilemma. I know it is in our communities, and even if it is not, it is us here. I know it cuts across. So now we also have another question that asks, what next where parents have divorced and are not ready to take their children for therapy? What next where parents have divorced and are not ready to take their children for therapy? And then can a dad get custody if the mother neglects the baby? Then in another case where both parents are dead, how should the guardian follow inheritance? And what are the legal requirements? So we have one where they have divorced and they're not ready to take their children for therapy. And then where there is neglect by the mother, can the father be given custody? And then now in a case where we have death of both parents, how can a guardian go about to taking up inheritance for these children or securing their inheritance?
Yes, these are all legal questions, but the one for therapy is basically
yes.
An issue that is of interest for literally everybody in the country. We have a children welfare officers, or children officers in short. And they are available in every sub-county. I think in every constituency, headquarters, there are children welfare officers. And if you see that children are suffering, as a good neighbor, you can actually go there and give a report. And they will come and visit the place incognito. Well, sometimes it takes some time. We always advocate that when they come and visit, they don't disclose from where they got the information. And they're capable of getting all the necessary material or evidence or details about the neglect of these children, and they can actually order these children to be taken for therapy. The most unfortunate thing in Kenya is that even as the children welfare officers do that, you know very well that the children may not have anywhere else to go. All right. If it was in other jurisdictions like America, and I'm happy that Patricia Makora is here from America, what they do is they give them to other parents by a valid policy direction or a court order. Patricia may be able to comment on that or help me on that. But in Kenya now, yes, you're going to question these parents, and then the children will still have to go back. We don't have rescue homes. We may not even have policies to put those children in foster homes. Yeah, the law says so, but maybe there are very few aunts or uncles or neighbors who are capable of doing that. Because if you give me a child after therapy belonging to my neighbor or my sister for that matter, I look at the expenses involved, among very many other things. But before I go further than that, allow me to talk to Patricia, and she can share a little bit about what happens in America in the event children are being mistreated and they need of care and protection. Patricia?
Yeah. Good evening, good morning. Yeah, in America, if children are being neglected or they are being abused, whoever notices that report through a document called the 51A here on the side of Massachusetts where I live. With that 51A, the Department of Children and Families will come and investigate. That report can be supported or unsupported because people can lie about other people. So if it is supported, the children will be removed immediately and they'll be in the custody of the Department of Children and Families who work alongside. They have foster homes, foster care homes. It's individuals who have given themselves to do fostering work. They are paid by the government to do that. They have gone through a lot of trainings on how to take care of children. So while in foster homes, the children can stay there for up to 1 year, usually, generally, and then they'll go to court and they can be given up for adoption if there is somebody willing to adopt them. The parents can also make up and go, they are sent to do like parenting classes, if it is alcoholism, whatever classes or whatever intervention. If they are successful and they follow everything the Department of Children and Family is saying, they can get their children back through the process of reunification. But it could take 1 year, 2 years, sometimes 3 years to do that. Yeah.
Thank you. Thank you very much, Patricia. We wish, and we are learning a lot because maybe from this conversation, we can approach the children welfare officers to try and lobby the government to put up some funds. And I know people of goodwill who can form associations or groups of foster, and the homes can be set up, and we can be able to rescue most of the children who undergo this kind of neglect. The other question was on inheritance. And what happens is that the law is very clear that our uncles, our aunts, our grandmothers cannot disinherit the children. Even if both parents are dead and they left some property, whether it is cash in the bank, whether it is motor vehicles, whether it is land or houses, those are the properties for these particular children. They rank number 1 in the inheritance. And even if they're not 18, these properties are going to be placed in the trust of these uncles or guardians for that matter. And then they will be able to be transferred to them when they reach the age of 18. There are also other arrangements like the shelter for these children, the accommodation and the school and all other needs for the child over that particular period. So the guardian just needs to go over to court, get letters of administration, and also be appointed as the managers or guardians to these particular children. So we only require a person of goodwill to volunteer to undertake that particular task. In the event that there is no such a person, then the children welfare officers take over, and there is a government department called the public trustee, which can also be able to take that particular task. The only problem with public trustee, sometimes they're sluggish and they may not be very, very helpful. So we call the children welfare officers or guardians. I think there was another question which I am missing out. Bernadette, you may wish to remind me.
I believe the one that probably where there is neglect of the baby, I think you have addressed that, where can a dad get custody if the mother neglects the child?
The answer is yes. A father, any parent, let me not just use a father, any parent has got the right to get custody. And even if I was given custody and 2-3 months down the line, it is discovered that I am not giving the best interest of this particular child, it can be taken away from me, just like it can be taken from the mother and be given over to me. So it's a continuous thing to take care of the interest of the child. And I say because there was that myth. If my child is a girl, maybe even 1 year or 2 years, that the mother should be that child. No, the mother should not have that child if she cannot give the best interest of that child. If I'm capable of doing it, the child will be brought over to me and the mother will be denied custody. Back to you, Bernadette.
Okay, thank you so much. I think we are at the tail end of our webinar. It is now 16 minutes past 7, but just a very last question is that in this case, the child is poisoned against the mother, such that the child, when brought to the chief by order, the child denies or runs away from the mother. At the same time, the mother is threatened with death and fears now to go to his grandmother to see her child. I think it is either a follow-up of the question where the child was being taken to the grandmother, and then now this child has been poisoned in a way that mentally they are told either the mother is bad or something bad is going to happen. And I think some of these things also happen where we manipulate the children. And I can see Grace has raised her hand. I'll give you an opportunity. I think the child has been manipulated so that now when they get to see the child, the parent, they run away in that case.
Yes, again, this is a societal issue.
Mhm.
And also goes back to the type of parents that we are talking about. I stay with a child. I poison this particular child, to use the words of the person who has raised it. I poison, and Madam Bernadette, you have talked about manipulation. And I say the mother is whatever, we can call her all manner of bad words, just to make sure the child sees the mother as the evil one. And when she sees the mother, she can actually run away because of how poisoned. And that is where now the children department comes in, and they are able to work with this particular child. And we can be able to see whether there was any manipulation, poisoning among very many, or coaching for that matter, by the other party. And allow me to say this, because when we are on the ground, or what we call Mamboko ground, sometimes things look a little bit different from even this webinar that we are having. If all fails, the friends cannot help. The various professionals, from the administrators to the pastors to the counselors and therapists, cannot help. Then we go to court. And the court is able perhaps to see through the manipulation, through the poisoning, through the coaching by one particular parent. And we can be able to subject this particular child to counseling. Now there is the Children's Act has got a court-appointed therapists who that program has not been rolled out. We are at the level of developing guidelines, how it is going to be rolled out, such that counselors are going to be appointed, and these counselors are going to be doing therapy for the children as well as for the families, just to ensure that they get back to some little bit of stability. Very, very akin to what Patricia has spoken to us about, even as we slowly develop some of these structures and institutions. And allow me to say this. You don't require a lot of money to go to court. You don't require a lawyer to go to court. These days, by virtue of our constitution, by virtue of other legal laws and policies that have been made in place, even if you file your document in your own handwriting, the courts are accepting that. It may cost you about 1,000 or 500 shillings to file those documents, Kenya shillings, and the court will listen to you. It does not matter that you're not quoting Section 3, Section 4, Section 5. No. All we want to know is that I need the custody of the children, or I need maintenance, or I need access to the children. Those are the only three things that the children courts deal with, all right? Or I need my children's school fees paid for. So let us not shy away from approaching the courts. If all fails, I am laying more emphasis on the structures that exist within the society, the friends, the family, the therapists, the clergy. If all fails, then we go to court. Don't fear approaching the court at any one particular time. There are children's courts across all the counties, and you can go to the children's court and you'll be granted the orders. that you require. The court will never throw you away saying you did not use a proper form or whatever. No, we are listening. The courts are listening to literally all the cases that go there to the courts. Back to you, Bernadette.
Thank you. Thank you so much, Dr. Kimani. I think I saw Elizabeth who had put her hand up. I don't know whether Elizabeth...
It was Grace.
It was Grace. Oh, it was Grace, yeah? Grace, go ahead and speak.
Yes, can you? I had a bad connection, that's why you couldn't hear me. My question goes back to the issue of the property left for the children, and who ensures that the guardian or the person who is who has the letter of administration is actually using the money for the intended purpose, and that they are not misusing, because we've had cases where people misuse the money that is left behind for the children. They take it like their own property, including selling. How do you ensure that the money is used for that purpose? Thank you.
Thank you, Grace, my fellow mediator. We work with Grace as well in mediation. Yeah, and once you get letters of administration, not only for the children, even for your own family, even for any other estate, it does not give you the right whatsoever to squander the property of the estate. And those who do so, do it against the law. It is a trust, is a responsibility that you have been given by that particular administration. Where it comes to the children, you cannot sell any single asset without the leave of the court. And you have to go back to court and say, why are you doing this? And then the court will also hold you accountable. You said you wanted to sell the car at 200,000 shillings so that you educate the children. So go sell and then pay to the school directly and give us the school receipts. And the children welfare officers will always be at hand to confirm that that is actually happening. So the guardians do not lord, do not take over as if it is their own property. It is a duty and a responsibility they have been given, perhaps without any pay for that matter. And therefore the courts will at all times be keeping tabs of how the property is being handled, how the money generated is being utilized, and how the welfare of the children is being taken care by the guardians. And that council established under the Children's Act is the one that is supposed to keep on tabs all those mechanisms to ensure the children do not get prejudiced in any way. I hope, Madam Grace, that is well answered. And for all these other questions, if we need to engage further, we are open to a lot of consultations and whatever. You have put your emails there. We can continue with the emails, or our phones are available. We can always continue with these consultations. But I asked Madam Grace, that was okay.
Thank you very much.
Thank you.
Thank you. Thank you so much, Dr. Kimani. I know there are other questions, but like we had said from the last webinar, we will still take up your question and answer in the next segment. I know we have really surpassed our time by 25 minutes, so I don't wish to, to engage any further, just because of, the time is not on our side. And so, but I want to thank each and every one of you for participating in this webinar. We still have other upcoming webinars, and please engage with us. Look out for the links that are going to be sent on the social media forum. We appreciate your presence and even engaging with us. And however, please leave your contacts behind so that we can always be able to email you and be able to tell you what is coming next. But on the 15th, we will have a webinar on wills and inheritance and succession when we're talking about divorce and separation. So at this time, I will take it back to Sylvia so that she can give us the next person who is praying for us as we end up. But I want to appreciate each and every one of you for your contribution, for your questions, for talking to us and engaging us. This has been a very meaningful engagement, and I've also learned a lot about the law and the rights of the children. So thank you so much and have a lovely evening. Sylvia, I'll take it back to you.
Thank you so much, Bernadette, for everything that you've done. You've just done a marvelous job at the moderation. Thank you, Dr. Kimani, for your insights. Thank you for everyone who contributed, Grace, Sister Florence, and even those who asked questions. We thank you all. This webinar could not have been a success if you are not able to attend or if you are not able to contribute to the topic. Thank you so much. I hope everyone has taken, even if it's one thing, home, and we'll be able to practice. In that, I wish to close the webinar with a word of prayer from myself. And let's close our eyes to pray. Dear Heavenly Father, we thank you for this opportunity that you've given us this wonderful evening. We thank you for the interaction that we've previously had about our parental responsibilities and our children maintainers. God, we pray that as we partake this journey of understanding more of our children and even taking care of them as parents, we ask you that you may guide us and may you protect us in everything that we do. As we retire later to bed, being an evening, we ask you that you may protect us. And until next time, we thank you and we glorify your holy name for everyone here. For it is in Jesus' name I pray, believing and trusting in Jesus' name. Amen.
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 Thank you everyone for joining up. Until next Saturday, same time, same location. But feel free to just inquire from us about the webinars. We have our emails down below from the emails that we've shared and even the mobile number. Thank you so much and be blessed.
Thank you. Bye bye.